O mga kababayan, ayan. Mukhang madidisgrasya na naman ang mga bangag mga kababayan sa pangalawang pagkakataon sa Korte Suprema sa kanilang isinampang impeachment case laban kay VP Sara. Dahil nahanapan ng butas mga kababayan eh. Oh, nahanapan nila ng butas etong pagsasampa at pagko-consolidate mga kababayan dito sa 4 na impeachment case sa isinampa laban kay VP Inday. Mayroon kasing dalawa mga kababayan na hindi pa supposedly tinanggap dahil lumalabag ito sa 1-year bar rule. Pero tinanggap pa rin ng mga mambubudol mga kababayan, mga congressman. Oh, kinonsolidate nila yung 4 mga kababayan, sabay-sabay nilang hiniring. Ang dapat sana, nireject nila yun right from the start yung dalawa. Hindi pa kami open para sa panibagong impeachment dahil wala pang 1 year. Pero tinanggap pa rin nila mga kababayan. At bagamat nireject nila doon sa Committee on Justice mga kababayan, isabay nilang hiniring Sabay nilang kinonsolidate. Parang binandel nila mga kababayan. At yan daw ang isa sa mga magagamit na argumento ng mga abogado ni VP Sara para ipabasura na naman mga kababayan ang impeachment na iyan. Panoorin niyo po
Bago to.
Bago.
Ang bitag sa pagsama-sama ng reklamo, karaniwang ginagawa ng Kongreso ang consolidation.
Bitag take note mga kababayan, ang bitag.
O yung pagsama-sama ng iba't ibang reklamo laban sa isang opisyal para mapabilis ang trabaho. Pero dito papasok ang trap o yung bitag. Ang argumento.
Pakinggan nyo ang butas mga kababayan sa isinampang impeachment laban kay VP Sara.
Kung ang House ay na-consolidate ng mga reklamong maaga, yung mga ipinail before February 26, no? Yung mga may paglabag sa 1-year bar rule. At mga reklamong tama ang petsa, yung sinampa or isinumite noong February 9 at 18.
4 yun, 2 mga kababayan lumabag sa 1-year bar rule. Yung pangatlo at pang-4, pasok na yun mga kababayan, pero pinagsama-sama nilang hiniring.
Pwedeng gawing butas yan ngayon ng mga abogado ni Vice President Sara Duterte. Yan na nga ba sinasabi ko. Okay?
Pwede gawing butas. Magwawala na naman dito mga kababayan itong mga ungas.
So ang tanong, bakit bitag? Okay, ganito yan.
Bakit?
Sinasabi ng mga abogado na hindi pwedeng gamutin ng mga bagong reklamo ang isang prosesong nagsimula sa illegal na paraan. Kapag pinagsama mo ang isang sira o yung isang illegal na reklamo sa isang maayos o legal na reklamo, yung buong bundle ay maaari ng questionin sa Korte Suprema.
Buong bundle lang. Pinagsama kasi nila, no?
Parang isang basket ng prutas yan. Kapag
sinalihan ng bulok.
may isang bulok, nadadamay ang lahat.
Pero sa totoo lang mga kababayan, lahat yun bulok. Pero pagpalagay na lang natin, na ang dalawa hindi bulok yun mga kababayan dahil accepted sa 1-year bar rule. Sinalihan nila ng dalawang hindi pwede. So ano pala dapat gawin nila, no?
No? Kapag may isang basket ng kamatis na sariwa, lagyan mo na isang bulok, damay-damay na.
Damay-damay na lahat.
Parang ganito sa consolidation trap. Okay?
Consolidation trap pala ang
Ay,
tawag.
punta tayo doon sa abuse of discretion. Yung pag-abuso sa kapangyarihan dahil ang appearance ad coetelam ay nangangahulugang hindi sinusuko ni Vice President Sara Duterte ang kanyang karapatang magdemanda o mag-file ng petisyon sa mataas na hukuman upang questionin ang jurisdiction ng House of Representatives. Yung target nila dito, yung yung grave abuse of discretion.
Usual mga kababayan, yung pang-aabuso ng Kongreso.
Okay, para dun sa iba na hindi pa masyadong familiar dito, yung grave abuse of discretion, ano ba to? Ito yung kapag ang isang sangay ng gobyerno o isang branch of the government tulad ng House of Representatives.
Abusado. Fortun, Narvasa, and Salazar. Yung mga abogado, mga kababayan ni VP Sara.
Parang ang bawat galaw ng committee ngayon. Okay? Kung itutuloy ng House ang impeachment, kahit may malinaw na paglabag sa 1-year bar rule, gagamitin itong basihan para sa isang petition for certiorari.
Certiorari.
sa Korte Suprema.
Mm.
Ito, diniscuss ko na din to several weeks ago. Dito sa kaso na to, sa impeachment na to, sasabihin ng Fortune Narbasa law firm na ang House ay nagpapakita ng pabigla-biglang desisyon at hindi sumusuri o sumusunod sa batas. Okay?
Grabe no, sila pa ang mga mambabatas, mga kababayan, tapos sila pa ang hindi sumusunod sa batas. Mambubutas. Tapos,
Naghirap ito. Mukhang may butas na naman dito.
another butas na naman.
So, ano yung epekto sa impeachment complaint nitong appearance at kutelam? Ibig sabihin nito, nakareserba ang karapatang idemanda ang House of Representatives sa Supreme Court anumang oras. Okay? Kine-question nila dito kung sakasakali kung legal ba ang pagtanggap pa lang sa mga reklamo noong simula ng February.
Oo nga no. Sana nga no, hindi nila tinanggap yun, mga kababayan, Dahil wala pang 1 year, malinaw doon sa Korte Suprema, not earlier than February 6. January pa lang, nagsubmit na yung dalawa, tinanggap. Tapos pinagsama nila, mga kababayan, doon sa dalawang sana pwede. Bakit nila tinanggap yun?
Consolidation trap.
Consolidation trap.
Pinipigilan ng House na pagsamahin ang mga reklamo dahil baka madamay ang lahat ng pagiging illegal. No? Yung lahat na naging illegal. Yung pinail na maaga, isinama doon sa pinail ng tama. Sabi ko nga kanina, parang isang basket ng kamatis.
Bulok na lahat.
Ilagyan ng isang bulok, di damay-damay lahat. Mabubulok lahat yan. Okay?
Aroy. So, paano na yan? Butata na naman sila sa Korte Suprema, mga kababayan. Magagalit na naman dito si Nangiwi. Si Dilima. Sasabihin na nila na Supreme Cuddler daw, sabi yung Ngiwi, mga kababayan festival. Supreme Cuddler daw ng Supreme Court, si VP Sara Duterte. And then sasabihin na naman ni Soto, impossible lang, impeachment ngayon. Ay nako, palibasa kasi, mga kababayan, eto talaga mga gunggong na ito. Abusado kasi, pinipilit kasi nila yung impeachment talaga, kahit hindi naman talaga dapat. Ayan, posible kayong mabutata. Nahanapan na naman ang butas, mga kababayan. Disgrasya na naman sila. Magagalit na naman dito ang mga ngiwi, mga kababayan, at mga bangag. Buti nga. Buti nga. Samantala, mga kababayan, tuluyan na palang binasura ng Korte Suprema yung motion for reconsideration na isinampa, mga kababayan, ng mga kongresista doon sa pagdedeklarang unconstitutional ang previous sa impeachment case laban kay VP Sara. Di ba sinabi nila, baka may unanimous mistake daw, mga kababayan. Kaya itong mga buaya, nagmosyon. At eto na ang resulta. Panoorin niyo po,
By a unanimous vote of all those participating, the Supreme Court en banc denied with finality the motion for reconsideration filed by the House of Representatives, which sought to reverse the Court's July 25, 2025 decision that declared the articles of impeachment against Vice President Sara Duterte unconstitutional. It affirmed that the fourth impeachment complaint transmitted to the Senate on February 5, 2025 was already barred by Article 11, Section 3, Subsection 5 of the Constitution. Associate Justice Alfredo Benjamin Caguioa took no part. Associate Justice Maria Filomena Singh was on leave. The court clarified the following points. First, the first 3 impeachment complaints filed in accordance with the first mode of initiating an impeachment, that is, Article 11, Section 3, Subsection 2, were not placed in the order of business within the required 10 session days. Session days as used in Article 11, Section 3, Subsection 2, or for purposes of the first mode of initiating an impeachment complaint, does not mean legislative session days. A session day for purposes of Article 11 in the Constitution was given its plain and ordinary sense, which the court interprets to mean a calendar day in which the House of Representatives holds a plenary session. Second, the court reiterated Gutierrez versus House of Representatives. However, it further elaborated that an impeachment complaint filed in accordance with the first mode of impeachment, which is Article 11, Section 3, Subsection 2, is deemed initiated for purposes of the 1-year bar in Article 11, Section 3, Subsection 5 when A. A properly verified an endorsed impeachment complaint is referred to the Committee on Justice. B. A properly verified and endorsed impeachment complaint is not placed in the order of business of the House within 10 session days or referred to the Committee on Justice after it has been put in the order of business within 3 session days as required by Article 11, Section 3, Subsection 2 of the Constitution. Or C. No articles of impeachment are transmitted to the Senate before the House adjourns sine die. This means that the initiation of an impeachment complaint must occur during the term of Congress. Third, the court affirmed the power of the House of Representatives to promulgate its own rules on impeachment. However, it clarified that Section 2 of the House Rules, as it is currently worded, requires the referral to the Committee on Justice even when it is filed through the second mode. The second mode is provided in Article 11, Section 3, Subsection 4 of the Constitution, where the endorsement of at least 1/3 of the members of the House of Representatives would be sufficient to transmit the articles of impeachment. In view of the current wording of Section 2 of the Rules on Impeachment, as drafted and promulgated by the House in its 19th and 20th Congress, the House may, optionally, upon its own prerogative, refer an impeachment complaint already endorsed by at least 1/3 of all its members to the Committee on Justice, but only for the following purposes. Number 1, to ensure that the endorsement of the members of the House is verified. Number 2, to confirm that the evidence supporting the grounds in the complaint exists and that every member of the House has been given a copy of the complaint, as well as the evidences supporting it. And 3, to respect the committee's prerogative to consolidate different formulations of the complaint, if any, so that only one complaint is endorsed to the plenary for transmittal to the Senate. The court observed that there is a fundamental difference between the first and second modes of initiating impeachment complaints. Thus, it said, and I quote, Article 11, Section 3, subsections 2 and 3 cover the first mode of initiating an impeachment complaint. Article 11, Section 3, subsection 4 covers the second mode of initiating an impeachment complaint. In the first mode, impeachment is initiated through the regular and deliberative process in the House of Representatives. A verified complaint may be filed either by a member of the House or by a private citizen with the endorsement of a member. Upon filing, the complaint is referred to the House Committee on Justice, which evaluates its sufficiency in form and substance and conducts the appropriate hearings. Only after favorable committee action does the impeachment process proceed further. This mode, therefore, emphasizes institutional screening and committee review. By contrast, subsection 4 introduces an alternative and a more direct mechanism for initiating impeachment. Under this provision, a verified complaint or resolution of impeachment signed by at least 1/3 of all the members of the House of Representatives immediately initiates impeachment proceedings. These provisions reflect a deliberate constitutional design. Subsections 2 and 3 provide a structured and committee-directed approach, while subsection 4 allows a streamlined initiation when a sufficient level of consensus already exists. Fourth, the court affirmed that due process of law applies to the impeachment process. It stated, and I quote, "The phrase right to life, liberty, or property should not be read with undue literalism. It must be accorded reasonable flexibility to achieve its intent of protecting inherent and inalienable rights that could not have been exhaustively articulated at the time of its framing. The Due Process Clause embodies a fundamental constitutional commitment to reasonableness, fairness, and non-arbitrariness. It envisions that we cannot have a true democratic and republican or representative state that is arbitrary and unfair. However, due process as it applies to the impeachment process is sui generis or in a class of its own. Full-blown trial happens at the Senate. At least for the second mode of initiating an impeachment complaint, it only requires 1. The grounds invoked in the complaint or resolution are those contained in Article 11, Section 2 of the Constitution. Number 2, the procedure is governed by the rules on impeachment promulgated by the House prior to any filing of any impeachment complaint. 3, As already provided by the current House Rules on Impeachment, all endorsing members should have been given a copy of the complaint and all its supporting evidence. The court also noted that the transmittal of the articles of impeachment should be done in a plenary session of the House, providing all the members of the House with full copies of the complaint and its accompanying evidence mentioned in Rule 4, Section 14 of the House Rules on Impeachment. Transmittal to the Senate, however, requires only a vote of 1/3 of its members for the first mode of initiating a complaint, or proof of the endorsement of a complaint by 1/3 of its members for the second mode. Fifth, the operative fact doctrine cannot be invoked by the party directly responsible in the commission of an unconstitutional act. Thus, it does not apply in this case. Finally, the court noted all the motions for intervention and pleadings filed by individuals who were not parties to the case. This resolution is immediately executory upon digital service on all parties in accordance with AM number 25-05-16-SC or the guidelines on the transition to electronic filing in the Supreme Court. No further pleadings will be allowed. The resolution and the motion for reconsideration and the separate opinions are being uploaded and served on the parties. Thank you very much.